Good evening. Welcome to the Chinese American Scholar Forum. I'm Jingjing Ye. I'm an attorney and moderator for tonight's event. Tonight, we usher in the third webinar of the Chinese American Scholar Forum. For those of you who tune in for the first time, let me give you a very brief introduction of the forum. So on the heels of the shocking arrest of MIT's Professor Geng Chen in January, and against a backdrop of large-scale institutional and law enforcement investigations targeting scholars of Chinese descent in recent years, with scores of ensuing terminations, arrests, and indictments, which, by the way, has mostly been conducted under the umbrella of the Justice Department's China Initiative. A number of Chinese and Asian American scholarly societies, alumni networks, and civic organizations joined force and started this forum to discuss, to reflect on, and to respond to the predicament and challenges facing the Chinese American scholars community. Tonight, we invite white-collar defense attorney Stephen D. Feldman to talk about the individual's legal rights in the context of law enforcement, institutional and/or regulatory investigations. Steve focuses his practice on guiding in-house counsel, businesses, and individuals in white-collar and securities regulatory enforcement matters, investigations, criminal trials, and other high-stake litigation. He advises companies and individuals seeking to overcome accusations brought by federal and state criminal prosecutors and regulatory agencies. Steve's clients have persevered when Steve has convinced criminal authorities not to prosecute clients for wrongdoing or to drop pending cases. Steve has also convinced prosecutors to reduce federal felony charges to misdemeanors and has obtained sentences of little or no jail time for clients facing extended periods of incarceration. So before we welcome Steve to the podium, also with us tonight is a panel of representatives of the co-sponsoring organizations and other distinguished guests. We will have a live Q&A session after Steve's speech in which select questions from the panel and the audience will be answered. We will integrate the audience into tonight's discussion. The audience is invited to submit questions through the chat function, which is on the bottom of your screen. Please keep in mind that this is a public forum and use caution when submitting questions. Please do not include confidential or private information in your question. The video recording of this webinar and the speaker's slides will also be posted online at the forum's website, casforum.org, as well as on YouTube in a few days. So now, without further ado, please join me in welcoming Mr. Feldman. Steve, the floor is yours.
Jingjing, thank you very much. Thank you, everybody, for inviting me to attend today. I really appreciate and I'm honored to be here. So thank you to the Chinese American Scholars Forum for having me. And thank you for the co-hosting organizations for sponsoring this event. It is a true honor, and it's as a white-collar defense attorney, my goal is to help people, and it's a pleasure to be able to speak to folks who are looking for advice and can use advice. And so thank you for letting me try to do my part to be of assistance to this community. I'm going to share my screen now and start with the proverbial PowerPoint that we all get to see these days on Zoom. So I'm going to talk tonight about, as you know, knowing your legal rights, practical guidance to respond to law enforcement, regulatory, and institutional investigations. I'm going to be giving overall advice today. I can't be each and every one of your lawyers today. And so I'm not here to answer, to be your individual lawyer and do your individual advice. Every case is different. And so one of the takeaways I'm going to recommend to you today is that if you are in a legal predicament, step number one is to get your own lawyer. So I'm here to give you overarching advice. I want to tell you from my years of experience as a prosecutor who sent people out to conduct these investigations, and now for 13 years as a criminal defense attorney who helps people defend against the government, regulators, and in-house counsel, how to protect yourself in these kind of situations. But what I'll be giving is general advice, not specific advice, and you should turn to your own lawyers. Jingjing already passed on my bio, so we can skip that onto the next page. I'm going to speak for approximately 45 minutes today. I'm going to cover these topics listed on the screen. After the 45 minutes, we're going to have another 45 minutes for question and answers from both, as Jingjing said, from the panelists from the sponsoring groups, as well as from the other attendees. I'm going to cover today these 5 main topics: how one becomes involved in a criminal or regulatory investigation in the first place. I'm going to speak about a university or employer investigation, the kinds of situations that one might run into on the job, where one's employer, whether that's a university or other institution, comes speaking to you to ask questions. I'm going to then turn to surprise interviews with law enforcement or regulators. That is when the FBI or the prosecutors come knocking on the door at 6:30 in the morning to ask questions, or when a regulator picks up the telephone and calls someone and tries to ask questions, or other ways that regulators or prosecutors or investigators will use surprise to gather information from somebody who has no expectation that they're suddenly going to be called. These are interviews or questioning done without an appointment. We're going to talk about the government search of homes, offices, or labs, that is a search warrant, and how practical strategies to be ready for a search warrant if you know that you're involved in an investigation and a search warrant is a possibility. And during the conduct of a search warrant, if one is being carried out at a home, office, lab, or other warehouse or other site, how you should conduct yourself during that search warrant to best protect yourself. And last, I'm going to speak to you about a proprietary smartphone app that my law firm has created called M&M Defend. It's a free app that gives guidance on these same topics on one's telephone. So it talks about a surprise interview, it talks about the government search of a home or office, it talks about receiving a subpoena or document request, and it gives advice on a telephone, so on your smartphone, whether that's iPhone or Google, Android, so that you're prepared and have that advice if the emergency comes up. So where are we? We all of us, no matter where we're from, no matter what our goals, we're all looking for the same thing. It doesn't matter whether you were born in the United States, whether you're a citizen by choice, whether you're someone who's come to live here permanently, or just visiting for a time and working. We're all looking for the same purpose of trying to support our families, of be successful, as I said, of contributing and doing meaningful work. And yet we're all going to face obstacles. And sometimes those obstacles are legal in nature. And tonight, my goal is to give you tools to overcome some of those legal obstacles that you might face, given the so-called China initiative. As I said, I was a prosecutor for many years, and I'm very proud of my time as a prosecutor. I went from a higher paying job in private law to do government service for less money because I wanted to make a difference as a prosecutor. And so I respect and value the prosecutors and the folks in law enforcement and what they do. But they don't always, they're not always motivated to do the things that I would say as a defense attorney are the right thing. When law enforcement brings cases, they're looking at different statistics, and I'd argue that they're judged by the wrong statistics. They look at the end of the year, how many new cases have they brought? How many guilty pleas have they generated? How many trial victories did they obtain? How much prison time did they get? How large are the fines? They look at these situations in an adversarial nature. That is, the prosecutors are against the defendants. But adversarial, well, that is our system, and that's something that is going to be one of my points to all of you tonight. it's not always the right way, especially in thinking about doing justice. The goal of the prosecutors, my goal and all of them when I was there, was to do justice. And yet it's when those are the statistics, it's hard to always do justice. They're not focusing on how many innocent people have we freed, how many cases have we dropped for lack of evidence, how many cases did we exercise our discretion and decide that we're not going to proceed with. And it's also important to know the prosecutors really have limited tools. The criminal law offers only limited flexibility. They can bring a case and try to obtain a conviction, or they can drop a case or say they're not going to bring a case in the first place. It's hard for them to calibrate their punishments. As to convictions, they can do misdemeanors. A misdemeanor is a conviction that's a year or less of jail time, or they can do a felony, which is more common, that's a year or more of jail time. Or they can say no criminal conviction law, we're going to drop the case. But they can't do often middle grounds. They can't bring a case and simply get money as a penalty. That's always up to the judge. They can't otherwise come up with alternative punishments. And so prosecutors, when we're in their wheelhouse, when we've become into their universe, there's only limited tools that they have in how they can deal with a case. And I'd argue that they are judging their success oftentimes by the wrong factors. But it's important to know, and this is the lesson I want to bring to you, is that you can overcome these situations, that individuals do have the power to fight and assert their rights. And again, I mentioned that the adversarial nature of this situation, of our system, is something I want to emphasize to you tonight. In order to persevere as the individual, you have to understand it's an adversarial situation, and you have to stand up for your rights and use your rights to the best of your ability to protect yourself. But by asserting your rights, you can slow or stop a criminal investigation, and people do have success doing that. You can, by standing up and figuring out the right ways to communicate, correct false assumptions that prosecutors may have, inaccurate facts that law enforcement has, or misperceptions. You can convince them that one is actually innocent and that the prosecutor should exercise discretion and not proceed. You can convince them that it's not a criminal case at all, that it's not right for criminal charges. Instead, there should be a regulatory proceeding, an alternative civil proceeding that ends up with a monetary fine and not jail time as an outcome. Or you can turn what might be a felony into a misdemeanor. That is, instead of a year or more in jail that one might be facing, facing less than a year in jail. Oftentimes, when one is prosecuted for a misdemeanor, they end up with probation. Or you can convince a prosecutor sometimes that a deferred prosecution is the outcome. That is, you sign an agreement that if you stay out of trouble for potentially, let's say, 6 months or a year, that the prosecutors at the end of that time will choose to drop the case entirely. And so these are these investigations, these can be life-changing decisions. And so that's why I think it's important for you to assert your rights, to know what those rights are, to be ready to stand up for yourselves in an adversarial system. I'm going to talk more about some specific examples, but I'll give you one. I represented an individual, one of 4 brothers, in an investigation where they were being investigated for stealing confidential information about a company and sharing it, that one who was on the board stole that information, shared it with the other 3 brothers, and used that information so that they could trade and make money in the stock market. So they were all visited simultaneously at 7 a.m. one morning by FBI agents, and they all had a choice. Do they assert their rights that they want to speak to a lawyer, or do one of them or all of them talk? And each one of them doesn't know what the other brother's saying because they're not being given the opportunity to talk to one another. They're all being spoken to by the agents simultaneously. And the agents, as I'm going to talk later, the agents are allowed to lie, and they do. One turns to one of the brothers and says, your other brother has already told the truth that you guys stole this information. And you should tell the truth too and come clean and protect yourself and save yourself. This is your one chance. And that brother at that time said, no, I want a lawyer. I'm not going to talk to you. Well, it turned out the agents were lying. The other brother hadn't spoken up. But they're allowed to do that in our adversarial system. And in the end, because none of the four brothers talked that morning, the criminal case never happened. These people went from facing potential jail time and changing to their lives to being able to walk away with a criminal case that was entirely dropped because they asserted their rights and decided not to speak. And so you need to know that in these kind of emergency situations, you need to carefully weigh what the right decision is. And you need to know that the people on the other side are not looking out for your rights. They're your adversaries. They're looking out for their own jobs, their own goals. How do people get involved in these kinds of investigations? So there's all sorts of ways, as many ways as you can imagine, that someone can get involved in a criminal investigation. One of the ways is mandatory filings, such as suspicious activity reports or currency transaction reports, SARs or CTRs filed by financial institutions. In those cases, someone may go into the bank and do a large banking transaction that is different in kind than the types of banking transactions those people are normally involved with. And that will generate a criminal, it generates a form that goes to regulators, and sometimes that will generate further scrutiny from authorities and could end up in a criminal investigation. People get involved in investigations through cooperators or confidential informants. What do I mean by that? A cooperator is someone who himself or herself is charged in a criminal investigation and agrees to cooperate with the government by providing information on others in order to hopefully, from their point of view, lead to the arrest or prosecution or investigation of other people. And so cooperators, from their point of view, the more names they can give, the more people they can get involved in investigations, the more leniency they'll get at sentencing. So the more names that they can put on a list of that they provided to the government that ended in prosecution, the better it is for them when they're sentenced for their crime. So cooperators have strong motivation to provide information, but they don't always have to provide truthful information. So a cooperator may provide the information about a name of someone who he's only heard something about, but not actually know all the details, or embellish to make it sound worse, or make up entirely people because he or she wants to curry favor with the FBI agents or prosecutors. And so cooperators are looking out for themselves, and that may motivate them to get others involved in investigations, rightly or wrongly. Confidential informants are people who are paid to give information to law enforcement. And so we have a system in this country where the FBI or other law enforcement authorities will try to recruit confidential informants, and they may also pay those confidential informants for information about wrongdoing or about people involved in wrongdoing. And again, those confidential informants, you would hope, only give information about true wrongdoing, but in exchange for pay, they may give information about others, or they may put others, somehow set people up to make it look like they've committed crimes so that the confidential informant can tell on them and make money. Whistleblowers also are avenues for investigations to originate or to a person to become involved. So these days there are statutes and companies often have hotlines where a whistleblower can call a phone number and provide information either to law enforcement, a regulatory authority like the Department of Treasury, the IRS, the Securities and Exchange Commission, or the FBI or others, and tell about wrongdoing that they're aware of. And in our system, whistleblowers who end up successfully making an investigation, making a case, for example, in the securities realm, can get paid up to 30% of everything above $1 million that the government takes in as fines. So if the government ends up fining a company for $10 million based on the whistleblower's information, that whistleblower can be in line for up to $3 million. So you can imagine strong incentives to tell on others and get an investigation going. And finally, subpoena responses. So the government may send out a subpoena seeking documents, emails, bank records, other materials. It could be an investigation related completely to somebody else. But if I'm involved in emailing with that person, or you're involved in emailing with that person, the government may get those emails in the course of the investigation and suddenly decide that there's something interesting in that email that's motivated them to begin interviewing or investigating me or you. And so one can become the collateral damage of someone else's investigation. So now let's turn to an interview from the university employer counsel or other investigators. So there are situations where a university or a company employer decides that they want to investigate the activities of their employees. And this is done because the employer gets information that there may be wrongdoing going on at their company. It could be sexual harassment. It could be theft of client money. It could be misuse of the company's or the university's tools or resources. There's all sorts of reasons that an employer will want to investigate. And so they carry out that investigation either by having internal people come and interview their employees and look over records such as emails of their employees, or by bringing in outside attorneys, someone like me, to come and do an investigation for the company and try to figure out what's going on. And so how can that come to light for you? You may get a phone call that someone from the university or your employer wants to speak with you, that a lawyer from the attorney's office, the in-house counsel, wants to interview you. So key point number one, as I said before, this is an adversarial system. The university, the company's attorneys, they are not your personal counsel. They're the attorneys for the company, and they're representing only the interests of the company. They're not representing your own interests. Now, sometimes those interests will coincide. Perhaps there's some incorrect assumption being made by the government or by somebody on the outside, or that perhaps a frivolous allegation has been made. And both the university and you know that it's frivolous and want to explain why it's wrong, and you'll be motivated to work together to prove that the allegation is false or to clarify the misconception. But other times, the university employer are in conflict with the employee. And so the number one piece of advice is for you to be getting your own lawyer. You need to hire someone who has experience in investigations, someone who's a former federal prosecutor, a former state prosecutor, someone with white-collar experience, who can help guide you through the system. What are they going to do? You're going to consult with your attorney to determine whether you want to attend such an interview. What you want to do with that person is go over the full history of what the subject of the interview is about. You're going to want to collect historical documents, your emails, your calendar entries, notes, contracts, disclosures you've made. And you want to determine based on that information whether you want to go forward and participate in that investigation. So you have a right to say no to your employer. I do not want to show up for your investigation. And that may be the smartest decision. Now, that could get you fired, and so you need to know that going in. But if telling the truth is going to get you fired, or telling the truth is going to create a bad record for you, there may be very good reasons to decline to participate. You also have to know that if you go into that interview, what's going to happen is the university is going to take notes. The attorney, the compliance person, the investigator, or the outside attorney are going to take notes of everything you say in that interview. And those notes don't stay internal to the company or university. You have to assume that those notes could, if appropriate, if there's a reason, ultimately be shared with law enforcement agents, with prosecutors, with regulators, with people from the outside. And so if those notes follow you, and if it's determined that something you said in that meeting or something they've written down that they've understood wrongly contradicts something you say in the future, you may in the future have to answer for why there's a contradiction. If you decide to go to that meeting, one of the other important considerations is whether you bring your personal counsel with you to that meeting, whether the university will allow you to bring that personal attorney to the meeting. It's important, and I usually recommend it to my own clients, that the personal counsel comes along, because that person takes notes on behalf of the employee so that the employee has a record of what he or she has said in the meeting. The university, they're going to have a record of what they understand you to say at the meeting, but sometimes they misunderstand, but you want your own record of what is said at the meeting. You also, as I've talked about, want to prepare thoroughly for that meeting by going over the history of the documents and trying to understand all the questions that might be asked so that you've thought about those questions in advance so you can answer them in the course of that interview. So some cautions here. As I said before, the university counsel is not your personal attorney. That counsel is looking out for the interests of the institution, not your personal interests. As I've said, again, this is an adversarial system. The university may say, because you're an employee and this is a confidential interview for purposes of them getting information for making legal decisions, that it's a privileged conversation, and they may advise you that because it's a privileged conversation, they don't want you to share the information that happens in this interview with anybody outside. That way the interview stays secret and attorney-client privilege. What do I mean by that? An attorney-client privilege conversation is a communication between a person and their attorney. It could be an employer and the attorney for their company. It could be a person and their private attorney. That's confidential. That is, just includes the person and their attorney, the employee and the company attorney, or the individual and his outside attorney. No third parties. And that is intended to provide legal information, to gain or understand legal advice. But it's important to know that the university owns that attorney-client privilege communication in the context of a company or university interview. That privilege belongs to the company, the employer. It doesn't belong to you. And the university can waive that privilege and decide to reveal that conversation that was otherwise privileged and confidential to regulators or law enforcement if they decide it's in their interest to do so. And ultimately, they can get cooperation credit from law enforcement or regulators by just agreeing to waive the privilege and sharing that information. So you should understand that while the conversation may be a privileged one between you and the company employer as an employee, and they've told you to keep it secret, they can decide not to keep it secret in the future and reveal that information. Turn to subject number 3 now, the surprise interview from law enforcement regulators. So as I've said before in the introduction, one of the tools of law enforcement is the surprise interview. At 6:30 a.m. Or 7 p.m. after work, they'll come knock at the door. They'll try to catch people before they're off to the gym. They'll try to catch people at night when they're first home from work. They might stop somebody as they're heading out to grab lunch. Anything they can do to initiate a conversation when the target, the person being interviewed, is not expecting it. And they use this to obtain information when the person doesn't have time to prepare, doesn't have somebody else to sit by them and help them through the process, and that they can then get information out of you. There's a lot of risks to agreeing to interview in that situation. What are those risks? Well, one, the agents are taking notes. They may not understand all the points you are making. If it's a technical conversation, they may not understand all the technical details. And so they can get it wrong. They're taking notes. Those notes, just like the university situation notes, follow you, but those notes can be wrong. 2, there's no one taking notes on behalf of you, the person being interviewed. You don't get your own copy of the notes. You can't both talk to them and take notes simultaneously. And so there's no one making a record of what goes on in that meeting for you. And if there are mistakes that you make or misunderstandings that come up in that conversation, the government may construe that as an intentional false statement. That is that you have something to hide, and so you are lying to them. And in this context, it's a felony to make a materially false statement to an agent in the course of an investigation. So if one were to lie or be perceived to lie, that can end up being a new and different crime of false statements. So the recommended response. And this, as I mentioned, I told you about the M&M Defend app. I'm going to get to in the end. This surprise interview scenario is set out in the app with these same guidelines. So what's the recommended response? 1, politely decline the interview in order to speak with your personal lawyer. You want to say, I'd like a business card so my lawyer can contact you later. I want to talk to my lawyer. I want to follow up with him or her before I speak to you. Please give me your card and we'll do this another time. One of the other things to do in this situation might be to actually record the interaction. So on the M&M Defend app and on lots of phones, you have the audio recording ability. And by pressing that audio record button, you can record these interactions with law enforcement. And so you have a record for your side on how to protect on what went on in that conversation in order to protect yourself. Follow-up. So you've said to them, look, please, I'll take your business card. I don't want to talk to you right now. My lawyer will get back to you and make an appointment. You don't have to have a lawyer lined up at that very moment to say that. You can say, I'm going to get a lawyer and get back in touch with you. And at that point, you should select an appropriate attorney who has experience in this realm, someone who is experienced in white-collar criminal defense. That lawyer will then reach out to the agent to determine what it is they want to interview you about, the areas of law enforcement interest, and to help prepare you and determine whether, just like with the university company interview, whether you want to be interviewed at all, and if so, prepare you for that interview. So what's that process? You'll want to pull and study your email and text messages, your notes, your calendar entries, contracts, disclosures, financial records, tax filings, whatever it might be relevant, to be comprehensively immersed in the background so that you're ready to answer questions if you decide to go forward. And if you decide to go forward, you're going to want to bring that personal counsel with you to participate in that interview. That person can take notes on your behalf and can defend you if they try to pressure you in the course of that interview. Or you may ultimately decide you don't want to be interviewed. You have a right under the United States Constitution, whether you're a citizen or a non-citizen, to say, I am not interested in being interviewed and speaking to the government, and I pass. And you are allowed to do that. And certainly I have situations in which I recommend that to the client. And without being interviewed, I think it's been essential to helping those cases go away. Why are these steps and processes important? One, the game is rigged here in the United States. The agents who come to your door at 6:30 a.m. are not doing so because they just think it's a convenient time to talk with you. They're doing so because they're trained to get information from you and getting you when you're not ready. Instead of making an appointment and saying, please come to my office, they show up at your house because they want to get information from you in a way that you're not prepared for. For example, an agent may say when they come to that door and you say, look, I want to get my lawyer and talk to you another time. They may say, look, we only have a few questions. But once they begin talking to you, it's never just a few questions. They've prepared for this interview with a long list of questions. And they can always say to you, anytime you say, is this going to be over soon? I only have a few more. But they don't only have a few more. They'll continue asking questions as long as you continue answering. They may say, can we come inside? You don't want to look like you're being questioned by law enforcement on the front door of your home. Can I come in? And once they come into your house, it's difficult to make them leave. These are trained law enforcement agents. They're often big people. Sometimes they're carrying guns, often. And so you may want to ask them to leave, and they're going to try to convince you to let them stay. And once they're in the house, it's more difficult to convince them to stay. They're also allowed to lie. They don't have to be truthful in the course of this interview. So they can say to you, for example, if you cooperate with me, it will go easier on you. But in truth, they lack the ability to go easier on the defendant. That's up to the prosecutors to decide whether to go easier on somebody in the course of an investigation. So what's going on here? The agents are trained with techniques to overcome the individual's caution. They're here to take advantage of the lack of knowledge of the individual about what the rules are, in order to obtain information to which they're only getting on your agreement that they're not necessarily entitled to. Let me talk to one other misconception people have. People often hear of Miranda warnings in the US legal system. That is where police on TV will say you have the right to remain silent. Everything you say can be used against you. And sometimes people think, if I am not given a Miranda warning, then the police cannot use the information against me. So they didn't Mirandize me, and therefore I can answer questions, and this will be off the record. Well, one, there is no off the record. Anything you ever say to these agents, whether it's on the phone or in person, is going to be written down and is going to be used against you if they can. There is no off the record. And two, these Miranda warnings don't apply in non-custodial interrogation settings. What do I mean by that? They have to give Miranda warnings when someone's been arrested, when someone's not free to leave. That's what the Supreme Court has said in their Miranda decisions. But at someone's house, you can say, look, I don't want to talk anymore, and shut the door. You can say, it's time for you to go. I want to get my lawyer. You're free to walk out the door and leave them sitting at your kitchen table in theory. So there's no requirement that they give you Miranda warnings before questioning you in that scenario. So look, these situations are important. These are adversarial. The agents are permitted to lie, and the lying matters. And I say up here at the very top of the slide, it's known to lead to false confessions. That is, a law enforcement agent may say to somebody, you had her blood on your hands, therefore you killed her. And the person thinks to themselves, I don't remember killing anybody. I can't imagine having blood on my hands. But if the agent says I did, it must be true. Maybe I blacked out, and therefore that's why I have blood on my hands. They wouldn't lie to me about something this serious. And then the person imagines how it could have happened, and they confess. And so there are people who give false confessions because they believe the authority of the law enforcement agents when those law enforcement agents stand up and say, you need to tell me this information, and I'm telling you the truth. And in fact, they're not always telling the truth, and it can lead to bad repercussions. So there's risks in interacting with law enforcement. They can decide that you're lying. As a result, they can try to seek leverage against you, saying, now, not only did you commit whatever crime we think you committed in the first place that we're investigating, we think you've lied to us, and that unless you cooperate with us, we're going to charge you with false statements. Similarly, based on what you say, they may try to broaden their investigation of you or your employer. And generally, it's most important to know that the government has essentially unlimited resources. If the government starts an investigation, it is unfortunately not an equal playing field. People are and can be financially ruined by attempting to defend against the government. And it ends in situations where people will sometimes settle cases or plead to lesser charges rather than engage in financially ruinous litigation with the government and try to clear their name. And so if you can cut off these situations in the beginning by asserting your rights, by understanding this is adversarial and refusing to interact with law enforcement in the first place, deciding you don't want to answer their questions, you're not going to turn over your documents. In appropriate cases, that can be the difference between being able to continue on your way and having a life-changing scenario go forward. Let's turn to the search warrant situation. So the government can obtain a search warrant, that is a document from a court, to search a home, office, a lab, a computer, a closed case. It could be a safety deposit box. It could be an off-site storage unit. It could be a trailer. It could be the trunk of a car. They can get a search warrant to search any sort of place. What's the standard? They need to go to a court and show that there's probable cause to believe that there's evidence of criminal activity, of specific criminal activity, that will likely be found at a particular location. And when they can show the judge that there's probable cause to believe that there's evidence of a criminal activity at a particular location, they then obtain a search warrant, which gives them permission to search and seize specified materials related to that particular crime from a home, office, lab, computer, cell phones, etc. If there's a search, here's strategies that I want to share with you to respond to that search. One, as I've talked about always, call your personal attorney. Get your attorney on the phone. Generally, you're not going to be able to stop this search, but you can take some actions to try to limit the harm that comes from this search. So you're going to reach out to your attorney. Hopefully your attorney will be able to come on site to your location as soon as possible during the course of that search and be able to help you right on site. 2, you're going to want to obtain the business card of the lead agent and contact information for the prosecutor, because there's going to be a prosecutor assigned to the case at this point, and your personal attorney can reach out to the prosecutor and reach out to the agent to get more information about what they're investigating and what this is about. 3, you want to confirm that the location listed on the search warrant is in fact the location the agents are searching. They are given in the search warrant a specific address that they are allowed to search, a specific location. It could be, the 2nd floor of 10090 Cedar Lane, apartment number 4. And if you're apartment number 5, you want to point out to them they're in the wrong place and get them to go. There are, of course, situations where the agents show up at the wrong place. There's also situations where agents get a warrant and put down the wrong address. Either way, you want to make sure that they're searching the right place that's listed on the search warrant. And you're going to want to get a copy of that search warrant. You're allowed to keep a copy of that document. In addition, it's a good strategy to video record the agents carrying out that search. Just like I said, in terms of an audio interview, that it's good to make an audio recording of an interview with an agent. It's good to make a video recording of agents carrying out the search warrant. So you are allowed to take video. They're at your office, your lab, your home, your warehouse. You're allowed to take video of them carrying out the search, showing what they're searching and where they're searching. Sometimes in those searches, they're going to want to search computers. They're going to have permission to take computers. If you can get them, and this is where your personal lawyer might be helpful, if you can get them to copy your computers on site rather than taking your computers and walking away with them, that can help you continue your work. So you can imagine if they take 5 computers from a lab and walk out the door with them, it could be months and months and months before you get your computers back and can continue doing the work. But if instead they can make a permanent duplicate copy of the computer right then and there, then you can continue your work while they do their searches on the computer. So oftentimes, if you can convince them to make copies and give them the time to do that, rather than having them walk out the door with your computer, it's going to be a big help. One of the things that can happen in a search warrant situation is the agents use the search warrant to turn it into a big interview session. So they can use that situation to try to interview everybody on premises. So if you're an office, they might say, hey, while we're here, can we talk to your secretary? Can we talk to your colleague? Can we talk to your subordinate? Can we talk to your partner? And try to interview other people, well, because they're on site while they're conducting the search. You don't want that to happen. So oftentimes what we recommend is that you close your office for the day and you send your employees home. That way, the government, of course, can go ahead and they have a search warrant. They can take and copy whatever it is they're entitled to take and copy, but it avoids all of your employees becoming the subjects of interviews right then and there. If there are particular files that are confidential, that are privileged, particularly attorney-client privileged, it's also useful to point those out to the law enforcement agents doing the search so that they can give those special treatment or not review them. Because even though they have a search warrant, they are still supposed to take care to acknowledge and protect the attorney-client privilege. And so they're not supposed to be searching documents. They can seize the documents that are privileged, but they're supposed to have a different procedure to look at those documents so that they're not invading the privilege. Talk now a moment about strategies to prepare for a possible government search. So I have situations where I'll represent employees. They know that they're involved in an investigation, an individual, and they're concerned that the government may come to their home, to their office, to search for evidence of potential wrongdoing. So first of all, there's 2 scenarios here. One, if you are not aware of an investigation, if you don't know you're being investigated, if you don't know that an investigation is going on at all, you have no obligation to retain evidence of wrongdoing. So if you did something 20 years ago and you happen to have information on your home computer, you're not obligated to keep that information sitting in your home waiting for law enforcement to show up and take your computer. And so you can destroy information before an investigation happens. You can put that away in some other location. You don't have to keep information of records of the worst thing you ever did in your life in order to help others build a case against you. But if you're aware of an investigation, if, for example, your employer has received a subpoena and they've sent out a hold notice about this investigation, or people have come and questioned you about the subject of an investigation. If at that point you destroy information, whether that would be computer information or materials at your home, documents, other records, if you destroy that information, that can be a new and separate crime called obstruction of justice. But again, that does not mean you need to have that information sitting with a bow waiting for law enforcement agents to show up and take away your laptop computer with the important information on it. Well, you can't destroy that laptop computer. You can move it elsewhere. You can get a safety deposit box and put it in a safety deposit box. You can send it to a friend. You could put it in your vacation home, either in another state or even overseas. You do not have the obligation to keep. You can give that information to your lawyer so he or she can review it and try to determine how bad that information is for you and what it shows in terms of your potential case. You're not obligated to keep that information sitting in your house, but if an investigation has started, you may not destroy that information. One other point here. There's a concept in the law called consciousness of avoidance, conscious avoidance. You can't pretend that you didn't know of an investigation if you actually knew of it or had reason to know of it. So people will sometimes want to be the ostrich, put their head in the sand and pretend they didn't know of the investigation and then destroy the evidence. If the government can show that you knew of or consciously avoided learning about the investigation and use that to destroy the evidence, that's nevertheless going to become an obstruction of justice crime. And so you don't want to be in a situation where you know of an investigation or should have known or somehow pretending you didn't know and destroyed information based on that false theory. Talked about my number one advice to you. You want to get, for any sort of investigation, you need to have an attorney. That's going to be critical for you to help understand your own strategy on how to deal with such one of these situations. As I talked about, there's the attorney-client privilege, and that protects your confidential communications with your personal attorney. How can you blow the attorney-client privilege? One of the mistakes people do is they communicate with their personal attorney over their company or work email or university email system. So the company email system is generally not confidential because the employer can monitor it. The employer can pull and review their emails if they want to. So if you communicate with your personal attorney on the company email system, that can be information that the government can seize. That's not a confidential communication because it's available to a third party, your employer. And so if requested by the government, they can turn over that information either voluntarily or with a subpoena, they can be required. And so if you're going to communicate with a personal attorney, make sure you don't do it on the company or employer email system. Set up, for example, a separate Gmail account or other email account, a private email system where it's just you and the attorney on those emails that you don't use for any other purpose and that you send from a separate computer. I talked to you before about our smartphone app that I recommend to you. Back in the days when we could get together in person, I would hand you out something, but this is better for the world we live in today. We've developed a smartphone app, and this app was to help in these very kinds of situations we're dealing with here. It provides on your phone instantaneous guidance to deal with a surprise interview, a search warrant being conducted at a home, a document subpoena. It includes on it quick buttons to get to the recording tools. You can press one button on the app and immediately be able to record an audio recording. You can press another button and immediately make a video recording. And those items are saved to your phone. They're not saved to the cloud or anything like that. And of course, it also contains contact information for me and other criminal attorneys. And so you have our cell phone numbers, our emails. And so if, God forbid, there is an emergency, you have this advice right on your phone at 6:30 in the morning if they're coming at the door or whenever that might be. And you can help give yourself quick advice while you get the attorney on the phone. Look, these types of interactions we've talked about today with law enforcement or employer investigations, they can be life-changing. What I would suggest is that with knowledge, you're knowledgeable, smart people. Armed with that right knowledge, you can stand up with your rights. You can lessen the harm to you. In 2019, I had an FBI agent come to one of my clients' houses and surprised him with questions. He didn't have a lawyer. He talked briefly to them, but ended the conversation. They gave him a subpoena demanding documents. He hired me. In that particular case, we chose never to speak to the FBI agents after understanding the full story of his conduct. We asserted his right not to produce any documents. Ultimately, a number of other people were prosecuted and pled guilty and went to jail. There was sufficient evidence to charge others, but there was insufficient evidence to charge my client, and he was able to continue his life. And the government met their goals of deterrence and all those of making examples of people by prosecuting the others. They didn't need to prosecute my client. And luckily he was able, because of choices he made, to continue in that situation. I'm at the end now, a minute over. I appreciate the opportunity to speak today. I recommend that you do download our app for free from the Apple Store or Google Play by searching for M&M Defend. You see the name up there. Call or email me if I can ever be of service to you. I'm here to be a resource. If you'd like a PDF copy version of these slides as a resource, we're going to put them on the CAS forum site. But I'm also happy to email you a PDF version of this presentation from tonight. We're now going to go to the questions. Thank you again for having me. It was a real honor.
Thank you, Steve. Thank you for the very informational and very educational speech, and it's really eye-opening. And during your talk, we received some questions, and we also received some questions during the registration process. So we're going to go over them if if time permits, and also we'll invite our panelists to raise some questions. But let's go to the audience question first. Here's a question: can conversation between client and attorney be used against client in the investigation process?
So no, a confidential communication between an attorney and a client is almost always going to be kept confidential. How can that, what are the exceptions to that? So if you have a third party in the room, so for example, if you're talking with your attorney and your accountant, the accountant is not your attorney, and it's no longer a confidential communication. And so that communication could end up being demanded by the government. Also, the attorney-client privilege covers past activity. You can't talk to an attorney about how to commit a future crime. So if somebody comes to me and says, Steve, give me advice on how I can commit a crime and not get caught, that is not going to be covered by the attorney-client privilege. And lastly, if your attorney is committing a crime with you, and they're your co-conspirator, that also isn't covered by the privilege. But generally, and the privilege, by the way, attaches from the beginning. So if you call me or some other attorney, from our very first conversation where you're looking to hire us, that's going to be covered by the attorney-client privilege.
All right, thank you. Here's another question. I think you have a lot of information, and it takes time for the audience to digest. So this might be a question you touched upon already, but if you can just let us know one more time. So the question is, if a person did not do anything wrong, could she or he simply decline interviews if they may see them as nonsense? Or under what conditions can one refuse to cooperate with law enforcement? And why does the system permit such adversarial behavior from law enforcement? It is so disheartening.
So as to the second part, there are legal systems where that are less adversarial, where the people think that the judges and the lawyers all get together and try to figure out the truth. But the belief, right or wrongly, is that in the US system, by having adversaries fighting it out, you get to the truth. I don't know whether that's true or not, but that's the system that we are currently stuck with. As to the first part of the question, the answer is yes. You generally always have the right, except I know there's questions about airport situations, but even there, you always have the right to say no to the government. I do not want to answer your questions. And certainly you have the right to say, I do not want to talk to you without a lawyer. If you say that I have a lawyer and I do not want to talk with you without a lawyer, the questioning is supposed to end immediately at that moment. So that is always a good thing to say. I do not want to speak with you without my lawyer present.
Thank you. So, okay, so you mentioned there's here's a question about airport encounters, and also we received many questions during the registration process, asking various questions regarding what the search and seizure happened at the border, and people, can you give us some, tell us what rights and what the constitutional right that you against unreasonable search and seizure, that right got discounted at the airport. And also, if somebody, the law enforcement agents come and just want to grab my computer, do I have to give my computer?
So the laws about the airport are different. The laws about the border are different than the laws everywhere else in the country, and that's the way international law treats borders. But that's the way United States law in particular does. So at the border, they have the right to do warrantless searches. That is where I talked about needing a search warrant to search a home, an office, a car, an envelope, mail, computers. At the border, it's different. They can essentially say, you don't want to come in? That's fine, don't come in. But if you're coming in, we have the right to search. And so they can take, they're supposed to have some sort of suspicion, but they can take computers at the border. And so there are some practical advice about that. One, for me as a lawyer, if I'm going across the border, I will mark particular files to make sure if I'm bringing files that are attorney-client privileged, in the computer system, we'll make sure that it's clear that it's attorney-client privilege. But even better than that, whereas they can search my computer at the border or demand it, they can't search mail. So I can take the same information and put it on a hard drive or on a thumb drive. I can mail it to where I'm going, and they're not allowed to search the mail without a search warrant. So whereas if I brought that thumb drive across the border, they could take it from me and search it. If I mail it to myself overseas, or I mail it from overseas to myself in the United States by FedEx, they can't just go and search that the same way. So if there is really particular information, such as on a confidential or proprietary information that you're bringing, that you want to bring across the border without government intrusion, there are ways to do that. You can put it in the cloud also, but I would recommend trying to think about that in advance of crossing the border. But the answer, unfortunately, is yes, they have rights to search at the border. And the answer is, I don't want to be searched. And they say, okay, then go back where you came from. You're just not welcome.
Okay, so I have a follow-up question on that. So do I have any, does the privilege, like I have privileged communication on my computer that I'm bringing with me, can I claim that I have a privileged information there that you should not search and, take a look at the the emails that's on my hard drive with my attorney.
So generally what they'll do in those cases, Jingjing, is they will take the computer, but then they'll bring in what they call a taint team, and they will try to have a separate team, separate from whatever the prosecution or investigation team, look at those emails to try to preserve the privilege. That's the way they get around that. But certainly, as lawyers, it's something we need to be cognizant of, and it is a potential hazard for us. Now, other things, you do not have an obligation to speak to them. So, for example, if they take your computer and you have a password, you don't have to tell them the password. So if your computer's encrypted, they can't make you speak and testify against yourself by giving the password. They might be able to make you put your thumb on your phone and open your phone for them, or if your thumb can open your computer that way. But they can't make you speak and tell them your password. You have the right to keep that silent.
That's mind-blowing for me that they can open it if you have a finger metric stored on your phone. You have to let them see, but if you don't have it, you only have a password. They do not have a way to get around it.
Yeah, it's arcane rules being applied to modern society.
That's fascinating. So okay, so panelists. So if you have any questions now, please jump in or raise your hand. Or if you have any comments, please you're more than welcome to make your comments now. All right. So while okay, hi Pei.
Yeah. Hi, Steve. I have a question for you. By the way, it's amazingly good, very educational talk you have given. Let's say you are in contact with an FBI agent, and he or she said that, well, you are not a target of our investigation. We just want to know some information or somebody else information that you know. Should you talk to them, or should you not talk to them, or should you find a lawyer before you talk to them?
Find the lawyer before you talk to them, I pay. I mean, without knowing the situation, you're gonna want to talk to a lawyer in advance of talking with the FBI. You're going to want that lawyer to interact with the FBI agent and with the prosecutor. As I said, the law enforcement's allowed to lie to you. So they can say, oh, well, you're not a target. Well, what do they mean by target? Who knows? And the fact that you're not a target today doesn't mean that you won't become a target down the road. So you need to be careful. And it may be that, it may be that you're simply a witness, right? You're standing on the side of the road and you saw a car go through a red light and there was an accident. Well, you had nothing to do with that. And they want to talk to you, and you can talk about who went through the red light or not and whether the light was red. It could be another situation where they think you were crossing the street and you caused the accident. So you need to understand whether you're purely a witness standing on the side of that road, or whether you're somebody who has information that they're interested in and that you could end up in the mix. So
Steve, once again, that the federal agents are allowed to make purposely on record lying when they are carrying on their official duties.
Yes, the lawyers are different. So if you were to talk to a lawyer, the lawyer's obligated to tell you the truth, but the agents are not, that they can lie.
And is that okay to, in the old days, you have a lawyer with you physically when you talk to an agent, but this day and age, would you say, oh, my lawyer is on the phone, so that's a three-way conference or something, or you and the agents sitting facing each other, but your lawyer is on the phone? Would that be same?
Every situation is going to be different. I try to be with my clients whenever I can. Sometimes it's been hard. I had to deal with a client in Texas where the COVID was very high at one point, and I was in New York, and the agents were elsewhere. So we did it by Zoom. But the best of all worlds is I want to be in the room with my client. I care less about whether the agent's in the room, but I want to be in the room with my client and to help him or her through the situation, if at all possible.
Okay.
Thank you. Zhigang, go ahead.
Hi, Steve. This is an amazing talk, very educational. Thank you so much. Now, I'm Zhigang Suo from Harvard University, professor there. So a specific question about, you talked about border control. So Professor Gang Chen is a personal friend, and we know his actually this is public information. His computers, his cell phones are detained at border without warrant and without probable cause. This is no reason, right? So and you just said, actually, I read it's legal. It's legal. This is the U.S. law. Now, but in this case, what should we do? This is very practical, right? We have to go international travel. So in his case, his devices are retained, causes tremendous disruption. As FBI cannot find useful information and make up things. So this is just a total evil. So what can we do to protect ourselves?
So, Professor, so you know, as I said, the rules at the border are difficult, and they're very much in favor of the government, and they allow the government to search and detain items. You know, and back in the old days, it wouldn't be like you were carrying your entire life's history with a huge file cabinet and a small package under your arm as you cross the border for just a business trip. And now that ends up being what you're doing. So I think if you're in, you know, if you're in the kind of world where I'm in, where when I travel internationally, I have to be worried that I have confidential information of my clients, and I want to be careful. I might, for example, bring a different iPad with a keyboard instead of bringing my laptop. And then I can try to work off the cloud and work off documents stored elsewhere when I'm there. And if they want to take the iPad that has essentially no information on it, they can do that. There are ways to bring, and same thing with a burner phone. I can bring a new and different phone for international travel purposes that I get just for that purpose from my employer. And that way it doesn't have every email that I've had with every one of my clients on it. So those are the kind of steps you can try to take. It is not easy. It shouldn't be that way, that we all have to jump through all these hoops. But there are steps for us to take to protect ourselves. And if we have reason to think or are worried, those are the kind of steps I would recommend taking. Similarly, as I said, you can send a thumb drive or a hard drive. You could send a laptop overnight via FedEx to yourself in wherever you're going or back to the United States. They cannot search the mail without probable cause and a search warrant. So they can take it at the border, but if you were to send it in a FedEx envelope, they can't take it without getting a search warrant.
Thank you. I have a slightly broader question. So this is a sense you said yourself. There's also a sense when I read documents of Gang Chen's case, this is a total asymmetry in terms of power between an individual and a government. That is I have no lawyer legal background, but it seems to be so unfair. So I know if you get into that situation, you have to follow the law. The law says whatever, government has an infinite power, individual has a little power, that's the reality. But if you want to fight for general justice in long term, what kind of things can people do? Oh, you're muted.
Has to happen sooner or later. Thank you, Professor. So I think so when you say general justice, I mean, what I'm focused on usually are helping individuals in their individual situations. And so there are particular things that you try to do to fight your case. There are particular steps You try to conserve your resources and think about how to fight through a case where the government has more resources than you do. There are steps people take to try to raise money. There's ways to try to battle in your individual case. More generally, you're talking about the political realm. You're talking about getting your representatives, whether that's your representatives in Congress and the Senate, whether getting the administration officials. I mean, things like this group is already doing by having a dialogue, like in the last seminar between this group and folks from the Department of Justice. But those are the ways. You use the media to tell the stories of people being mistreated. Those are, quite honestly, Professor So, not my areas of expertise, but those are the thoughts that I would have on how you would deal with those kind of situations in terms of general justice.
Thank you.
Okay, Yiguang, go ahead.
Steve, thank you for the advice. And one of the advice I really like is that when university try to interview you, and you should not take the interview without your own lawyer. That's a wonderful advice. However, practically, it's very difficult to exercise it. For example, there are many kinds of interview from university offices. For example, you just look at your CV. Oh, look at the CV. Your CV looks very interesting. So the general counsel can make an appointment, say, oh, we want to have an interview with you for 30 minutes to look at your CV and what kind of collaboration you have with a foreign country, for example. That's one type of interview. The other type of interview is that because these days, different government agencies, funding agencies, have different requirements about your CVs when you submit research proposals. And university try to protect themselves or protect us, and they want to add some additional information attached to the CV. So this additional information, for example, and do you have any kind of advisory board member, and internationally or domestically? And how many hours do you work for that advisory board? Do you take money for that? So this is almost like a routine interviews between university grant office with faculty, depending on the agencies. And it's really impractical that each time you want to say, oh, I want to have a lawyer to talk to you about this. It's pretty much that the obligation for faculty to work with university to get the proposal submitted. So the question to you is that, will that informal information or additional information of CV will be shared to the government agency, certainly will be used to get us if federal investigation come in?
I think you always have to assume that if somebody is taking notes in a meeting about what you're saying, those notes will follow you. So if you're interviewed about your CV, your connections with other organizations, and they're taking notes, that there's a chance if the government asks in the future, if you become the subject or interest in some way of an investigation, that those notes can be produced to the government. They're not necessarily going to be kept secret. And I agree with you, it is impractical sometimes. So, I mean, I guess the strategy might be, if you know that there's an interview coming up and you can understand what the subject matter of that interview is by asking, what is it we're going to talk about? I want to prepare. Depending on that detail, you might want to talk with your personal lawyer about the interview in advance and at least prepare for it. You can practice the questions with your lawyer. I try to go over questions with my clients so that hopefully they've thought about the question. It's not the first time in 2 years that they're thinking about some subject like an organization they were affiliated with in the past and how much they were paid there and how long that affiliation lasted for. Or you can pull old documents and try to review the subject of what they want to talk about. The other thing I'd suggest is that you can end these interviews. If in the interview you get to the point where you're uncomfortable, you're concerned, you're worried, you might say, look, I don't want to continue this interview today. I want to talk to my lawyer. I want to review materials. Let's finish this up tomorrow. Now, what the result of that might be, could be you get fired. because you've now not complied with the university's directives. But it could be they say, okay, we want to make sure everything you tell us is accurate. We'll give you the time to review whatever documents you want to review before we continue the interview. So again, as you know, there's no one size fits all. It's going to depend on the situation, but you may need to suggest that, in order to get it right, you want to take a break, you want to take time to prepare, you want to take these interviews seriously from the get-go, knowing that they can follow you into the future and be used against you.
Thank you, Steve.
Thank you so much, Steve. Meanwhile, we have received a lot of questions from our audience, and I thank you for your active participation. Again, I will select the questions. I think that's touching on different points of Steve's speech tonight. So let's change gear a little bit. Here, this question: how easy it is for let's go with this question. How easy is it for prosecutor to obtain a search warrant? So Steve, can you just enlighten us? Although the whole game looks like it's rigged against an individual, the government have the power, but there are some thresholds that the prosecutors need to meet and overcome before they can have a search warrant before they, because at the end of the day, if it goes on trial, they need to prove beyond reasonable doubt, which so that's a very high bar. So if you can enlighten us a little bit from that perspective.
So well, let me answer this. We go to a more general point. So the government conducts their investigation. A more regularly used tool than the search warrant is a subpoena, and I referred to those document subpoenas. So the subpoena has a very low level. So when I was a prosecutor, literally, if we have an open investigation and I want to get information, I would take up the subpoena form out of the drawer, stick it in the printer, and run the subpoena, and then I could mail it out. That was all that I had the power to issue a subpoena, just because I was a prosecutor at age 33 and wanted to. And what could I subpoena? I could send it to the credit card company and get your credit card records. I could get your credit report. I could send it to the bank and get your bank records. I can send it to your employer and get information about your employment records. So the subpoena is the easier tool that the government uses, and they use it all the time and very easily. The search warrant is more invasive, right? There's the Fourth Amendment says that the government can't go into your home without a court without a judge issuing a search warrant. So the government has to have probable cause before they show up at your home or your office or your car, or your lab, or your storage unit and take things from you. And so in that situation, the government needs to put in an affidavit, a statement under oath, usually by the case agent, explaining why there's probable cause to believe that there was a crime committed and probable cause to believe that evidence of that crime will be found at the particular location. They need to be able to show that the search warrant is not stale. That is, there's reason to believe that the evidence is still there now, not that it was there 6 months ago and could be gone. And they need to be able to explain precisely what the evidence they're looking for. They can't say, we want to take everything from Steve Feldman's house. They need to instead say, we think Steve Feldman was involved in dealing drugs, and we want information related to drug dealing, such as a computer that might have drug records, drug paraphernalia, scales, baggies, and things like that. And so they have to be precise about the types of materials. But if they do all that, they can then go to the judge and they can get a search warrant. And that can be done quickly. And when I was a prosecutor, I would have situations where we would turn around the search warrant, in a morning, half a day, and get it to the judge and have it done and executed that night.
Right. Brian, I see that you.
Yes, Steve, this is Brian. I think the information you gave us today is very helpful. I do have a follow-up question for that. So is it possible the first time the prosecutor knocked at your door and reads the warrant, reads the search warrant at the same time?
Yeah, so there are situations where law enforcement agents, it's usually the FBI or other agents, will come to do an interview and will also execute a search warrant. There are situations like that, but oftentimes those are separate, that they'll try to do an interview first, because when there's a search warrant being carried out, you know then that you're really in the mix of the investigation. You may be less willing at that time to answer their questions. As I said, they're trained in how to do this, how to best get the answers. And if you think that perhaps you can talk your way out of it, they'll try to talk to you first, see what they can get in that, and then they'll come back another day with the search warrant.
Thank you.
Okay, so Jigang, you have another question?
Steve, so now today you're mostly focusing on individual against government. There is for university professors, there's also individual against university. So we at university know the university process is totally opaque. For government, you charge somebody, actually there's legal document online, we can actually look what is being charged as a third party. So other faculty cannot see what is being charged against our colleague. Sometimes we try to get information because we love this particular colleague and we don't think he has done anything wrong. We ask university, hey, what is this guy doing wrong? We're getting no information. And in all these cases, especially related to China initiative, we only know Gang Chen has been supported by his university. All other cases, university dropped the ball or even just openly declare are in cooperation with the government.
Fire them right away in many cases.
Yeah. So I guess the question is still two questions. The simple question is what an individual can do or other faculty members can do to open up the information. The second general question, I basically think this is unfair. Such a powerful entity of university, lots of resources, and in collaboration with government to hit on individual. And the process even more evil than right? It's totally opaque. It's just wrong. So that's the second question. What can we do in the long term just to make this country a better country, university a better university?
Right. So well, I'll start with the second question first. You know, from it's a common issue, right? That the university also has potential liability. It's the same thing with companies when employees are involved in investigations. And so I end up being in situations, sometimes I'm representing the company and sometimes I'm representing the employee. And so when you're representing the company can be prosecuted. How does a company commit a crime? Through the wrongdoing of the employee in the course of his or her employment. So if the employee did in fact do something, it's not just he or she who's on the hook. Their employer may in fact be guilty of that crime as well. And so what does the employer do? The employer tries to figure out whether it is in fact guilty, and how does it curry favor with the government to convince the government not to prosecute it? And sometimes that involves, as we say in my world in the vernacular, throwing the employee under the bus. And so the company, the employer, the university will look out for the institutional interests, so they think, and not for the employee's interests. And that's why, you know, going back to what I've stressed, it's an adversarial relationship. Everybody has their own interests. And so the university, the employer, they are looking out for their institutional interests, or what they think they are. I mean, they may well have it wrong, that their interests should be everybody working together, but and the government will give them cooperation credit for turning on the employee, for cutting the employee loose, for changing policies, for providing information about what the employee had to say, for investigating the employee, and then turning the information from that investigation over. So yes, you're absolutely right. Not only is it just the government, it's the government and the employer, the university, the institution after the people. And it is overwhelming. You know, what can you do in the university? It's a private organization. You know, you as the faculty have some limited power. Perhaps the faculty can stand up as a group and demand change. Perhaps if it's important enough to enough people, they can convince the university to take action. But you're right, it's a very difficult situation, and it's a difficult power dynamic to face off against large institutions that have set in their ways and aren't about being transparent.
Thank you, Steve. So Kai, go ahead.
Yeah, first of all, I want to make a thank you, Steve, for the wonderful talk. I want to make comments about earlier discussion about computer and a cell phone situation across the border. I think many universities, including Princeton, for example, have services when you travel overseas to certain countries, and they will you can have a loaner computer and a loaner phone. They give you a separate phone number, another email address, and so on and so forth. Certain countries such as China, Russia, and several other countries actually have the law saying that if your computer is encrypted, and they will force you to unencrypt it, otherwise they can reject you across the border. So for that reason, many universities have such a service. So I just follow Steve. I think another question from the audience I thought that was interesting, I'll just ask on behalf. This audience attendee says, I'm a US citizen. Last time before I board an international airport, aboard at the international airport, the border control agents initiated a long conversation about my research grants and collaboration inside the gate until 10 minutes before my departure. Can I contact my attorney before or during the conversation or refuse to give information to that situation? What is the strategy to deal with the requests for information in that situation?
So you know, each of these situations are going to be different. Certainly you have the legal right not to share information with them and to not have that conversation. So if they are initiating a conversation, you can say, I prefer not to talk about that. You can go back and ask them questions. What's this about? Why are you questioning me? And you can also say, I don't want to speak with you about without an attorney. This is a sensitive topic. If you want to make an appointment, we can make an appointment to speak. Those are all things you can say to try to deal with that situation. What might they do? They have some power over you in those situations. They can pull you aside potentially and question you before allowing you to cross the border. So they can make things more difficult if you refuse to be cooperative with them. But it sometimes is better for it to be, you know, depending on the situation, for it to be, you know, to cut off that conversation and deal with whatever difficulties than it is to continue that conversation. I mean, that's a judgment call on your behalf, trying to figure out what is the potential exposure I have in this conversation.
Okay, Hai-Pei, go ahead.
Quickly, Steve, here's a question about government surveillance and slash civil liberty issue. Technically, if you are an FBI agent, if you want to get a surveillance permit or going through the FISA court, what is your odds of getting one? And usually how long is that? And the second, with related to that, if you are using WeChat or other social media social media stuff, you are, let's say you are a citizen of the United States, and in that social media group, there are non-citizens, either in this country or in overseas. So in that kind of a mixed situations, where does our law about not monitoring our own citizens without a FISA permit start and ends?
Steve, you're muted.
Done it again. So let me try to speak specifically about surveillance. So the common way that surveillance is done in this country is through wiretaps. And to show that to get a wiretap generally, the government needs to show that there's a particular phone being used for calls related to wrongdoing, for criminal activity, and that there are not alternative means to get to that phone. So for example, they can't get somebody to make recorded calls with the person, or they can't otherwise have opportunities to speak with the person who's using that telephone for wrongdoing. It's also usually they need to show that there's multiple people on that telephone call. That is, that the phone is being used by, to call in by several people for criminal conversations. And in those situations, and so to do that, to get that wire, the prep work they need to do is they do records of the actual calls, the tolls, not what's said in the calls, but the number of calls, how many calls are going into the phone, who's making those phone calls. And so the government will first produce for the court information about the number of calls going in and the identity of the callers, and be able to say that those callers are involved in criminal activity with the person they're calling on the phone. And then with that information, and with information about that these people are involved in criminal activity, they can then get a judge to approve wiretapping the phone. But it's a big process. That, as opposed to a search warrant, getting a Title III, a wiretap application, is onerous. And the part of actually wiretapping the phone is onerous. They don't just record the calls by having a recording system that no one listens to. They have people listen in real time to those phone calls. And so for general criminal investigations, you then have to have FBI agents or other agents, DEA agents, sitting in a phone room, essentially listening to every phone call as it comes in. And they're only allowed to listen to phone calls that are related to criminal activity. So if it turns out to be a purely personal call, they have to minimize, that is, turn off the call and stop recording it. So the process of doing a wiretap in a criminal investigation is onerous, it's time consuming, and the only reason it generally goes on is if you have reason to think that there's somebody who uses the phone as a hub of criminal activity for communications. In the international intelligence arena, that can be different. The FISA court is a specialized court for intelligence investigations, but generally the same concepts apply. That is, you have to give an affidavit, you have to show a basis to believe that there's wrongdoing going on, that these people are involved in that wrongdoing, and you have to have a basis to show that they're using the telephones, and that phones are likely to provide information. So if you can get that permission to do a wiretap, then you can tap that phone line, and generally they're going in the criminal realm. They're going to be tapping phone lines of it could be domestic or foreign people, but generally it's going to be domestic people. So I think, so that's how a wiretap generally works. You're talking about WeChat. To get chat information, you have to either go to get the actual phone, and then you can search the phone and try to pull information off the phone. And so you have to get the phone and have a search warrant for it. Or you have to get the provider of the service to turn over information to you. And so you would send a search warrant to the provider and get the provider to turn over information that they keep stored. So again, domestically, if it's a provider who keeps that kind of information, then you, with a search warrant showing that you have reason to believe there was a crime committed, that there's evidence of the crime at that spot, the law enforcement can get that information and review those conversations. Did I answer that enough, Professor So?
Sure. Yeah. Thanks.
Professor Chu, thank you.
Okay. So, okay, we have a lot of questions that's been raised by the audience. And we also have audience raising their hands or wanting to speak. So I will invite the Jack Wu to speak, who has been bearing with us for the longest. So Jack, if you're here, you now can speak.
Yes, can you hear me?
Yes, we can hear you.
Okay, my question is, when we are ready to make either audio or video recording, do we need to ask for permission, or we can just go ahead and do it?
Steve.
So Jack, if you're in a, you should, the safest step is to tell the people that you are recording. So that's always the safest. In certain states, like New York, New York's a one-party consent state, meaning in New York, I can secretly record a conversation and I don't have to let people on the other side know. The safest step, because every state is different, is to be open about it. Say, I am going to record this conversation now, and if you have a problem with that, let's not talk. Similarly, when you're going to videotape, you say, I'm going to videotape this conference. So videotaping is different. If they are in your office, you're allowed to videotape them if they're doing a search warrant. But again, the safest thing is to tell them, we're going to videotape this search warrant being executed.
Sure, let me try to rephrase. We need to let them know we are doing this recording, but we don't need to have their permission to do so.
Right, I think that's right. I think that's
Thank
right.
you. Thank you very much, Steve. I already downloaded your app. Looking forward to talking with you later. Thank you.
Good, thank you.
All right, thanks, Jack. Okay, so let's go back to Professor So.
Hi, Steve. Thank you for being wonderfully clear. You're remarkable. Thank you. So now you also mentioned you have once been prosecutor. Well, I want to ask from prosecutor's perspective. I use Gang Chen's as an example, but the question is more general. So with Gang Chen's case, when he was arrested on that day, our FBI has the video conference and also Twitter announcement send out lots of misinformation. And this misinformation was also contained in the criminal, initial charge document. Why there misinformation, we know that it's for sure now, because the subsequent document, this information disappeared without explanation. Now, the general question is, again, this is abuse from common people in the street like me, right? It's abuse of power. You use misinformation immediately quoted by all the major universities. And the public heard about this. Oh, Gang Chen this is such an evil person. And then once, because of this, I suppose misinformation is not scrutinized. I guess a prosecutor is not get punished for sending out misinformation. Now, it's ironic for a person in the street, for you to charge somebody misfile a document, and you can file a document full of rubbish, cannot stand up for scrutiny. You have to withdraw without explanation. How can this happen?
So, I mean, the prosecutors try to limit what they say in press releases to what's in their charging documents, into their public, either the indictment or the complaint. And the complaint, to get it to be an official complaint, as in the case you're referring to, there has to be somebody swearing to a judge that this is the truth. So, you know, to make that kind of mistake is awful. sometimes people may do it on purpose, but I would imagine that it is really just a mistake of overexuberance, a mistake of thinking you have a great case. It is terrible. They then do the press release, and that press release follows people for the rest of their lives. I'll give you an example. I had a client who was charged with hacking into his former employer's email system. They said to steal important confidential information. And ultimately, we convinced the prosecutors that he should get a misdemeanor, and he got probation. And when he was arrested and charged, it was a big press release about how he was stealing this important confidential information. But when they agreed to a misdemeanor and he got no jail time, there was no press release. There was no, statement that in the end this guy got no jail time and just a fine. So he's out of his career forever because he's seen as the guy who stole important information. Even though in the end it was a minor slap on the wrist that he got. So yes, the press releases can be very harmful, and it's a part of the imbalance here. If I put out a press release as the defendant's lawyer, nobody really covers it, but when the government speaks up, the world listens. And so there's an obligation to be very careful as you're a government prosecutor. I mean, we took that obligation seriously. But everyone's going to have a different approach.
All right, thank you so much. Now we're 10 minutes over. So I think what I'm going to do is this. We can't get to all the questions, but this is again, it's a very in-depth and not Steve is astoundingly knowledgeable about this area of law. So what I'm going to do is I'm going to invite another attendee who has been waiting to speak. And after that, I will invite two of our panelists to raise your question, to choose a question from the audience that you think that I missed, I haven't asked, but you think that should be raised. And after that, we'll wrap it up. So if that's a plan, let's go to our attendee. The next one in line is Yongping Zhang. Yongping, now you can talk. Are you there? Let me see. Ask to unmute. Oh, did I unmute?
He's muted.
I am just toggling this.
Okay, can you hear me now?
Yeah.
Yes, we can hear you.
Yeah, okay. Yes, thanks so much, Steve. So my question is, you mentioned that you can request the officer, if they have the search warrant, you can request that the officer to just copy the computer from your office or maybe from your home instead of having them take away your computer, right? But can the officer insist on taking it away just without you? Okay.
Yes.
And also you mentioned that when you are at the border, you can mail out your computer or your devices, but how would that work? How do you have the time to do that?
So before you leave, so if I know that I'm going to another country that I'm concerned about, or I'm coming back from another country, I can go and go the day before to FedEx and put the computer in FedEx and have it come to the United States that way. So I'm not bringing it over the border.
Oh,
or I can put a thumb drive at the day before FedEx. I'm not suggesting at the airport, at the gate, you can do that. I'm suggesting the day before you prepare by doing it.
Gotcha. Okay, thank you so much.
All right. Okay, so panelists, now it's your time to ask a question on behalf of the audience, and please raise your hands. Any volunteers?
Okay, I can volunteer. There is a question about a China initiative from the audience. So various organizations has petitioned the Biden administration to drop China initiative. But so far we haven't heard anything official, anything at all. So from your lawyerly perspective, what is going on? If something's so bad, what's going on?
So as I heard from the last forum and the speakers there, it did sound like there was already some effort between the new administration to have conversations with the community about the China initiative and their concerns. So it sounded like a good first step that DOJ was engaged in conversations. I imagine, having been in government, that these are the kind of decisions that are being taken carefully. So there's going to be a great deal of discussion. There's political ramifications. All of us know that China remains a very hot topic for everyone and for the new administration, even with the change of administrations. And so I do think that this administration has an approach to law enforcement that's very different than the last one. I expect that we're going to see a different way of enforcing the law, but they also seem to have a more thoughtful approach to things, and sometimes being thoughtful requires more time. But that's just my guess from my perspective.
So there's one extreme form of expression in the street. You probably heard this. China initiative is just as racist as the China virus. So I may or may not take this view, but it sounds reasonable from certain light.
Oh, I agree with you completely. Look, if there was a Jewish initiative, I would be. Could you imagine how I would be reacting? So, I mean, there's just no question that it is the most awful name, and it could only be coming from this administration. And then to target not China, right? It is targeting people here in the United States. It is targeting individual people. It's not targeting a country. People are not the sum of their origin, their family history, the place they happen to be born. We are all much more than that. So I agree with you completely.
Thank you.
Steve, maybe I will ask a question. There's a question from the audience I thought was interesting. Are investigators of government agencies, let's say grant agency or university administration, they're not law enforcement? Are they also permitted by law to lie to people in the course of an investigation?
So the investigator, so again, the only people who really have an ethical obligation not to lie are the lawyers. So if you're dealing with a lawyer, the lawyer is, their ethical duty is not to lie. But otherwise, and from the law enforcement side, the law does not prohibit, the case law does not prohibit law enforcement investigators from lying.
What about let's say Department of Energy or National Science Foundation or University General Counsel? I guess General Counsel cannot lie because he or she is a lawyer, but let's say your associate provost.
So I think the regulators, who are the regulatory investigators, could lie to you, and that there would be nothing illegal for them about doing that, particularly in the course of their investigation. As to the university, can your employer lie to you? Probably there's no law in particular against that. So yeah, if the employer has a reason to lie to you, and it's not a lawyer there like the general counsel, they could probably get away with that.
All right. One more we can, okay, Kai has a question. I guess, Kai, go ahead.
Well, I just want to make a comments about the question I think Zhigang raised about on behalf of the attendee about the China initiative issue. I think that several Asian American organizations such as Asian American Advancing Justice or APA Justice and UCA and and several others are working on with the Asian Pacific American Congressional Caucus to see whether it's possible to have a congressional hearing on China Initiative. I think that would be a good step to probably make an effort to change how things are done. Because we know that, I think that kind of effort requires the public support. I think anyone who is interested in doing that should try to, support those organizations and try to participate and sign petition and so on and so forth to make that kind of thing happen.
All right. Thank you so much. Thank you, Kai, for this comment. And again, in the interest of time, we have to wrap up. Today we have a very outstanding speech by Steve and a very lively discussion by our panelists and our attendees. So today's video recording will and Steve's slides will be posted online at the forum's website, csforum.org, as well as on YouTube in a few days. If you want to contact Steve, you can also find his contact information on the announcement page of the forum of today's talk. So I think it is very important for the community to come together to discuss topics like this one, like what we have covered tonight. I think whatever the challenges that the community is facing, even like the complex and unfamiliar questions such as the criminal law that we covered tonight, please know that there are a lot of people out there like Steve who can and are willing to help. So I believe with solidarity, reflection, and actions, the community will persevere, will survive, and will get better together. So, I want to wrap up tonight's talk with a ancient poem from Tang Dynasty. It's called 莫愁前路无知己，天下谁人不识君, meaning you're not alone, we're all your friends. So with that, thank you everybody. Thank you for your time. Thank you.
Thank you.
Thank you very much.
Thank you very much.
Thank you, everybody.
Thank you so much.
Thank you.
Appreciate it.
It's good.
Bye.